Phil Shiner, welcome to Hard Talk.
It's nice to be here.
Now, the British system of military justice, that is the military policing their own and punishing their own, it's been established for centuries. Are you suggesting that system is broken?
Well, from the evidence in Iraq, there is no doubt at all in my mind that system does not work. And if you think about it, you've got soldiers investigating other soldiers, you've got a commanding officer sitting in private, making a decision after interviewing just the soldiers, not any of the other people, the Iraqis or whoever, that there's been no breach of the rules of engagement, and that's usually the end of it. But if it does go to the military police, then you've got soldiers investigating soldiers, and they send it up to another institution of soldiers, and eventually they get tried before a panel of soldiers. Now, that patently lacks independence, which is a fundamental requirement.
Are you suggesting to me you don't trust the military? That's what you seem to be saying when you talk about soldiers judging soldiers in a rather disparaging fashion. It sounds like you have no trust.
I would draw a distinction between the military justice system and the military system generally. I think the military were badly let down in Iraq by the politicians and the civil servants, and I would not wish to be misunderstood, and I act for families of soldiers killed in the Iraq War. But the military justice system, no, it doesn't work.
What's changed? We've talked about Iraq so far in this interview. I suspect most of our interview will be about events in Iraq. But let's face it, it's not the first war we've fought. It's not the first deployment of British forces overseas. We've got the Geneva Conventions. We've got UN conventions on torture, which have been in place for some time. Why has Iraq raised these concerns for you?
Well, I think the first problem is that there was no Security Council authorisation. So it was an illegal war. And
in your opinion,
well,
not in the opinion of the British government.
Well, in the opinion of just about every lawyer who knows anything about international law. The problem is that in the Iraq War, firstly, there was a failure to plan, which led directly from the fact that the US and the UK assumed that the Security Council would authorise it and then didn't. And the second problem is that the Human Rights Act has come into force in October 2000. So the Iraq war and occupation was the first occasion when this was going to be tested. And that's the big problem here, that the Human Rights Act requires that if the state is implicated in a death, the right to life, or in torture, the prohibition on torture, then there has to be an independent inquiry. Independent inquiry, not a military inquiry.
Everything you've done in the last few years representing Iraqis who have alleged abuse performed by British forces in Iraq, everything suggests that the system works, because in the case of Baha Musa, for example, an Iraqi who was killed while being held by British forces, in the end the law lords agreed with your case that the Human Rights Act was relevant to that particular case. So what's the problem?
Well, the problem is the House of Lords left it to the High Court to decide whether there should be an independent inquiry. Having the Human Rights Act apply is neither here nor there, really. It's the independent inquiry that brings accountability. And just Thursday, the government have admitted that they have to pay damages, but they refuse to hold the inquiry. Now, the judge advocate at the court-martial said that Musa had died from 93 injuries committed by a multiple of soldiers, none of whom had been charged, he said, and I quote, as a more or less obvious closing of ranks. That's judge speak for a closing of ranks, a cover-up.
But there were court-martials in the case of Baha Musa.
Well, what happened was that one soldier pleaded guilty to inhumane treatment. He pleaded not guilty to manslaughter. 6 other soldiers, including the commanding officer, pleaded not guilty to a variety of offences, and everyone who pleaded not guilty got found not guilty. So that all you're left with is one man who pleads guilty to inhumane treatment, gets 12 months, with the judge saying who did it. The night that the court-martial finished, Sir Mike Jackson, who was on a panorama programme, said, well, I'm very uncomfortable. We're none the wiser. No one has a clue as to how Baha Musa died, who did these things to him, who committed these 93 injuries, and more importantly, why was he and all the other men kept stressed, hooded, deprived of food and water, deprived of sleep, and some of them subjected to noise. So here you have the reintroduction of the 5 techniques which were banned by the Heath government in 1972.
Is this what you're essentially saying, that there is a cover-up involved here in which the British government, working alongside the Americans, let's not forget, after 2003, was specifically and willingly involved in abuse of human rights and then covering them up? Is that your contention?
I can't know exactly what happened until we have the inquiry. But it's very interesting that a great number of senior military witnesses in the Moussa court-martial made it clear that the policy on hooding was written down. One said that it reflected, as he put it, verbal and written NATO policy, enter the US. It's interesting also that when Moussa died, partly because he'd been hooded for most of the 36 hours that he survived, did we move to stop hooding? No. Why? Because we were saying to ourselves, well, the Americans are already complaining that our interrogation techniques are too soft. What will they make of us taking out hooding and stressing? Which the Americans were hooding and stressing and all of those things alongside us in the same detention facilities that we were using.
But you make it sound as though there's been no investigation at all into the sorts of allegations that were aired in the Baha Moussa trial. In fact, there have been real, serious investigations. One, led by Brigadier Robert Aiken, spent months looking at what happened in 2003, 2004 in terms of British treatment of detainees and allegations of abuse.
But it's, again, the military, investigation of the military. Aiken did not write to me or anybody on my side of the fence and say, well, what do you have?
To quote Sir Richard Dannett, the head of the army, he is independent, open and honest.
But he's not independent, he's military. And he's not open, because if he'd wanted to know what someone like myself had to say, and I have read every sheet of paper from the court-martial, he could have written to me. If you think about it, if we had a system where our interrogators and tactical questioners were trained to hood and stress, and that's the evidence in the court-martial, if all battle groups were using hooding and stressing as a standard operating procedure, and if the permanent joint headquarters at Northwood knew about it all along, which they did, does that not suggest to you that there are questions to be asked at the very highest level of politicians, civil servants and senior military? I'm a human rights lawyer. There's no hierarchy of human rights. There's no difference between the rights of Baha Moussa and Gordon Gentle. Gordon Gentle's case is a case...
Gordon Gentle being the young Scottish soldier who died in the war.
And I've just finished dealing with his case in the House of Lords. I've acted for years for the Gurkhas. But I maintain that if there are violations of human rights, then we need to get to the bottom of it. The evidence that we have taken from 5 survivors of a particular incident in May 2004 strongly suggests that the UK soldiers in that incident have taken 29 people into detention. 20 hours later, 20 of them are dead and in body bags, and these 5 survivors, we're due to see the other 4 survivors, making 9 in all, give evidence that they have heard at close range people being executed, shot, strangled. Now, there are clearly questions to be asked as to what has gone wrong there. They didn't interview my 5 clients in circumstances where they were remotely likely to tell them, to say what had happened. They interviewed them when they were still being interned by the very people who'd half beaten them to death, shot at them so they thought they were going to be executed, and then apparently shot or executed at close range a number of their fellow Iraqis. So they're not likely in a detention facility run by the UK to say, well, this happened and that happened. What is now going to happen is the Royal Military Police have reopened the investigation, but above all, there'll be a High Court hearing in the next few months, which will decide should there or should there not be an independent inquiry. Now, frankly, there has to be,